All right, this is case number 2115-8395. This is Bank of America versus Lewis Ford Jr. The matter is before the court, set on for a hearing on the application for entry of default judgment. The default of the defendant has already been entered in this matter where there was no answer to the complaint. The court then set the matter over for a hearing on actual entry of the judgment itself. For the plaintiff in this matter, your appearance, please.
Good morning, Your Honor. Mark Splain appearing on behalf of Bank of America.
All right, thank you, Mr. Splain. Good morning to you, sir. Give us your P number for the record at this time.
P number 82148.
All right, thank you, counsel. Do I have on this record Lewis C. Ford Jr.? Lewis Ford Jr., if you're on this Zoom, please say something at this time. All right, for the record, the court is calling for a Lewis C. Ford Jr. residing at 243 Newport in the city of Detroit. The defendant has not responded to the court's call. The matter was set on for 9:30 a.m. It is now 9:48. Given that the defendant has not appeared at this time, did not otherwise respond to the complaint and petition in this matter, the court will now enter the judgment by default on the terms as prayed in the complaint and offered in the proposed consent, strictly the proposed judgment by default, and the total amount is $17,811.94, and the judgment is entered for that amount at this time. Thank you, counsel. We'll get the order out to you, sir.
Excellent. Thank you, Your Honor. Have a good one.
The court now calls case number 21-160-206. This is NCB Management Services Incorporated versus Geraldine Curley. The matter is before the court on an application for entry of default judgment. A default has already been entered in this matter. The court then set the matter over for today's date for the application for entry of the actual judgment. The record should reflect the defendant has not otherwise responded in this matter to the complaint and the proceedings up to this time. For the plaintiff in this matter, your appearance at this time.
Your Honor, Athena Agustinos on behalf of NCB Management Services, P63407.
Thank you, Ms. Augustino. I'm looking now for Ms. Geraldine Gurley, living on Blackstone Street in the city of Detroit. Ms. Gurley, if you are on this Zoom, please say something at this time. Again, the court is looking for Geraldine Gurley, address on Blackstone Street in the city of Detroit. Defendant has not previously responded to the court's call, nor has defendant responded to the complaint in this matter. Accordingly, on this date, the application for entry of default judgment will now be granted based upon the terms as prayed in the complaint and offered in the proposed default. The total amount then of the entry is $4,040.88. The judgment is now entered. A copy will be forwarded to plaintiff as well as to the defendant in this matter. Thank you, Madam Counsel. Good day to you. The court now calls case number 21-160-351. This is Therapy Unlimited LLC versus Ronnie Lumpkin. The matter is before the court on an application for entry of default judgment. The default of the defendant has previously been entered regarding this matter. The court set this hearing on for the defendant to have opportunity, if they wish, to respond to the application for entry of the judgment itself. Your appearance for the plaintiff in this matter, counsel.
Good morning, Your Honor. Dylan White, P80755, appearing on behalf of Therapy Unlimited, plaintiff.
Thank you, counsel. And I'm looking now for Ronnie Lumpkin. Mr. Lumpkin, a person residing on Archer Street in the city of Detroit. If you are on this Zoom, please say something at this time. The record should reflect that the matter is set on for hearing at 9:30 a.m. It is now 9:52. I am looking for Ronnie Lumpkin. To the complaint in this matter or other proceedings and has not responded to the court's call. Accordingly, now the court will grant the application for entry of default, and accordingly, the judgment will enter on the terms as prayed in the complaint and set forth in the proposed application. Total judgment amount will be $15,582.68. The order is now entered, and counsel will be sending out a copy to you as well as to the defendant in this matter. All right, thank you,
Your
sir.
Honor.
All right, good day to you.
Good morning.
The court now calls case number 21-156-542. This is Midland Credit Management versus Lonnie Twitty. That's Twitty is that last name. The matter is before the court on an application for entry of default judgment. The record should reflect that the default in this matter was previously entered. The court set this hearing for entry of the actual judgment and to give defendant opportunity to appear in court and show cause why the judgment should not be entered. Defendant has not previously responded to the proceedings in this matter. Your appearance for Midland at this time, please. Your appearance for Midland.
Judge, they're due to be here at 10 o'clock.
Is that 1:10? Oh,
Yes.
I'm ahead of the time. Looks like I got a note on there saying, yeah, I do see it now, 10 o'clock. Thank you, Madam Clerk. All right, and we'll recall that particular matter. Thank you. All right, the court now calls case number 21-160-736. This is Complete Imaging LLC versus City of Detroit. The matter is before the court. Looks like I've set this on for an adjourned pretrial date. Your appearance for Complete Imaging at this time, please.
Good morning, Your Honor. Joe DeCruz on behalf of the plaintiff, P84445, Your Honor.
All right, and good morning to you, sir. And for the City of Detroit, counsel, your appearance, sir.
Good morning, Your Honor. Gregory Patterson, P75963, standing for the attorney of record, Michael Auten, on behalf of the defendant, City of Detroit.
All right, thank you. Thank you, Mr. Patterson, and good morning to you as well, sir. It looks like I kind of recall that there have been some efforts moving forward towards resolving this, but you guys were stuck somewhere, or am I getting this mixed up on something? Somebody go ahead and update me, if you will.
Your Honor, I said I'm standing in for the attorney of record. My understanding is what there have not been significant movement in settlement negotiations. I do understand there is some outstanding discovery. I believe a proposed stipulated order was sent over. We have not received a response. Of course, you can file a motion to compel there, but we're always willing to engage in settlement negotiations.
Got it. Thank you, counsel. So I take, go ahead.
Judge, how are you? I'm good. How are you?
Wait a minute.
Your Honor, I apologize. I'm in like 3 Zoom courts. I apologize, Your Honor.
All right. Well, you know where your priority has to be.
You don't do that to me, Your Honor.
Your priority has to be with the brilliant and good-looking judge.
Yes, Your Honor.
Judge, I thought you were going to say opposing counsel for a second. I was going to be really flattered.
And Your Honor, that would be you, since I'm in front of you.
All right. Now, tell me what your thoughts are. Counsel he says that there is some outstanding discovery that the city is waiting on, and that you've got some stuff you need to get to them, sir.
Your Honor, we were served with defendant's discovery December 15th. It is December 26th, so we are about 12 days overdue. We will get these over to the city post haste, probably by the end of the week. So as Mr. Patterson knows, he doesn't have to file motions with me. If he emails me, I'll get right on it. Mr. Patterson, please, if you can you just give them to me in Word? Can you send them over to me?
I'll have it done.
Thank you, sir. And then,
Right,
Honor, after that, we usually, me, Mike, the whole City of Detroit and me, we work well together as far as negotiating and getting these things out and done. So I believe as soon as I get the discovery over and move forward with this, I don't think, I know the city stance on MRI bills, and I know what their numbers are as far as them go, and so does my client. So as long as there's no fraud or anything else that the city sometimes has to deal with these bus cases and whatnot, I don't think that we're going to have a problem settling it.
All right. All right. So yeah, you mentioned fraud, and then the other one is significant deviation from the norm. So hopefully there is some normalcy to some aspects of this. All right. So I will go ahead. Would it be meaningful to bring you back 30 days hence regarding this matter, or do you need more time than that?
I think, Your Honor, if Mr. Patterson sends me over the discovery in Word that's outstanding, we could probably have it back to him by the end of the week, and 30 days would be fine as long as brother counsel's okay with that.
Certainly, Judge.
All right, very well. So I'm going to go ahead and set it up just about 30 days out with the notation of the court is indicating to the parties that the discovery should be turned over post haste as soon as possible. The parties have worked well together, and the court is aware of that. And it will make it more meaningful 30 days hence, obviously, if the discovery has been exchanged and there's been an opportunity to review the same. So, Madam Clerk, if you have a date that's like 30 days out, I'm sorry.
March the 1st.
3/1/22 is going to be the date on this, and that's going to be 9:30 a.m. 3/1/22, 9:30. The court finds good cause for the adjournment of the pretrial in this matter, and it's set over for that particular date. I wish you well, gentlemen. See you soon.
Always a pleasure, Your Honor. Nice seeing you.
Likewise, gentlemen. Mhm.
Take care.
All right, this is case number 19-146-8. Strike that. 19-146-406. This is Budget Rent-A-Car System versus Monawar Al-Shahadi. The matter is before the court for a subsequent date of hearing after a determination by this court granting judgment after trial. And I know that there is a third-party defendant in this matter, and I believe that's AAA Auto Insurance. And the case continues because I believe it seems to me that there is some effort to make sure that if the third party holds responsibility here, that party would be in line to contribute. Your appearance for the plaintiff Budget at this time.
Good morning, Judge. Craig Sheener appearing on behalf of Budget.
All right, and give us your P number on the record, if you will, Mr. Shana.
32-245.
All right, thank you, sir. And good morning to you for the defendant Monawar El-Shahadi.
Good morning, Judge. Eric Frankie, P47232.
All right, thank you, Mr. Frankie, and good to see you. Good morning to you. Do I have someone from AAA in this matter, if you will?
You do. Good morning, Your Honor. Andrew Tetro appearing on behalf of the third-party defendant, AAA.
Thank you, Mr.
Yep.
Go ahead with your P number, Mr. Tetro. I'm sorry.
79743.
All right. Thank you, and good morning to you as well, sir. I did receive a copy of the minute order for entry of judgment against Monawar El-Shahadi. It looks like my hands are just getting on that, so I will sign that consistent with the court's ruling and determination in this matter after trial. But I understand that there's an outstanding matter as to whether or not AAA has a role to play in this, and I believe that Mr. Frankie has something to say about how we proceed regarding this matter, sir.
Yes, Judge. We have agreed to a stipulated order of dismissal that should be presented to the court by Mr. Tetro's office. I agree based on presentation of his motion that there's really no claim. And so we've agreed to dismiss the third party claim, and then this would resolve the last open claim in the case, and it can be closed.
All right, Mr. Tetro, that makes sense to you, sir?
Yes, it does, Your Honor. A stipulated order of dismissal was submitted to the court earlier this week. I doubt it's made it to your desk yet.
All right. Do you have that? Do you have that in a form where you could email that to my clerk today so we can get that all signed up?
Yes, I do. Can you provide me with your email address?
Absolutely. That's going to be Latifah, LATIFAH @36360 36districtcourt.org.
District Court, all spelled out one word, .org.
That's correct. And
Yes, I can email that right after I hop off here.
Sounds good. And I'll get that signed up today, and we'll get it back out to you. She'll likely email that back to you as well, and then we'll put it in the mail, and you can get it all circulated. Anything, Mr. Shaner, anything you need to bring to my attention at this time, sir?
No, Judge, if you've signed the amended judgment, I assume we'll get a true copy.
Yes, sir. And I'm signing that as we speak, and I will make sure that that these are trued up as well. You'll get copies will be circulated. All right.
Thank you, Judge.
Thank you, Judge.
Sir. Good day to all.
Thank you.
You too.
Take care.
Second here. Do I have Midland, someone representing Midland on this Zoom?
Yes, sir. William Hill, appearing on behalf of Midland Credit versus Lonnie Twitty.
Got you. And that's 21-156-542 Midland Credit Management Incorporated versus Lonnie Twitty. The court called this previously, of course, before the call time, and so that's why you heard me pull it up the way I did. Mr. Hill, you've indicated your appearance regarding this matter. I am now looking for.
Yes, sir. William Hill, P28608. We're seeking an entry of a default judgment at this time.
Right. The court now is looking for Twitty, Lonnie Twitty. If you're on this Zoom, please say something. Looking for Lonnie Twitty, a person occupying property on Hayden Street in the city of Detroit. If you're on this Zoom, please say something at this time. The record should reflect the defendant that the court previously entered the default in this matter where the defendant has not responded to the complaint or any of the proceedings. The court set the matter over for today's date for entry of the judgment itself and to give a defendant opportunity to come in if they wanted to do so and show cause why the judgment should not enter. The defendant has not appeared and as indicated, not previously responded to the proceedings in this matter. Accordingly, the court will now enter the judgment by default as prayed and as offered in the proposed judgment. The amount will be $762.41. The judgment is now signed at this time. All right, thank you, counsel. We'll get that right out to you, sir.
Thank you, Your Honor.
All right, this is case number 21-154-940. This is Affiliated Diagnostics of Oakland versus City of Detroit. The matter is before the court after the denial of the defendant's motion for summary disposition. The court set the matter over for a pretrial conference on today's date. All right, for the plaintiff, Affiliated Diagnostics, if you're there, please say something at this time. All right, for the City of Detroit, if you will.
Good morning again, Your Honor. Gregory Pattison, P75963 here on behalf of defendant, City of Detroit.
All right, thank you, Mr. Patterson. So I know that Mr. Lowe was here the last time around. Have you had opportunity to speak with him, or any information you want to bring to my attention at this time, sir?
I have not, Your Honor.
All right. So I know it's shortly after 10. You have any mechanism by which you could reach out to Mr. Lowe to see if he's coming into this hearing today?
I can certainly step out and try and reach him, Your Honor.
All right, if you would, and then just when I see you back in, I'll come right back to you.
All right, sounds good, Judge. Thank you.
All right, thank you, counsel. Good day. All right, this is case number 21-240-960. This is Angela Crockett versus Leona Crittenden, Crittenden. The matter is before the court on the filing of an appeal from a determination by a magistrate of this court. The matter has been set before me. By way of record, it was assigned to another judge, and then I see a reassignment to this court. I have no problem with that, but I don't know why that happened. All right. I'm looking for Angela Crockett at this time, please.
Here, Your Honor. Can you hear me? Good morning.
Yeah, I hear you. I hear you loud and clear. Good morning to you, Ms. Crockett. All right, and now I'm looking for Leona Crittenden. And the name Crittenden sounds so easy for me to do, but when it has Don at the end, it seems like I'm having a problem with that. So it's Crittenden. Say it for me, if you will.
Crittenden.
Crittenden. All right,
Yeah.
I got you. And my name being Donald should not make that so hard, because Don should just flow, but it just don't want to seem to come out like that today. All right, looks like there's something of a request for a de novo hearing in this matter, based upon the matter being before the magistrate. That would give the parties the right to be heard in front of me. So I take it, have you all talked about this to try to see if you could find a way to resolve it among yourselves? Have you even taken an opportunity to try to talk about that at all?
No, sir.
No, Your Honor, we have not talked.
Okay, got it. All right, so let me do this then. Let me have you raise your respective right hands to be sworn at this time. You do solemnly swear affirm that the testimony, statements that you're about to make, they are the truth, nothing but the truth, so help you God.
Yes, I do.
Amen. Yes.
All right, and both individuals, for the record, have done so. And hold on just 1 second, I'm coming right back to your case. Mr. Patterson, sir.
Thank you.
Yes, Judge. I just called Mr. Lowe's office, went to voicemail. I also attempted to email them, have not gotten a response at this point.
All right, sir. What's your thought on this? I mean, you guys engage on a regular basis. I could set it over for next week and try to get back in here to see where things are, sir.
Your Honor, generally speaking, I tend to offer every courtesy I can. If you recall, this is a case with what I believe was a staged accident. If you recall, we reviewed the video. This case, my superiors have taken a fairly hard stance on. And so I don't know that I can, in accordance with the orders from my higher ups, agree to simply hold this over. So I would ask for a dismissal. I don't like doing it, Judge. I want to make that clear for the record, but I've got my marching orders.
Oh no, your stance and your position, your collegiality is well established before this court. It certainly, I think that's one of the that's one of the benefits to establishing a track record of collegiality, is that when you're asking for something that might seem extraordinary under normal circumstances, the court has a track record of knowing that courtesies are typically extended. So what I'm going to do, Mr. Patterson, is I'm going to wait another 8 minutes, and at 10:20, if the other side has not appeared on this, sir, I'm going to enter an order dismissing the case. So I'm extending the courtesy from the court for 20 minutes. The case was set at 10. Actually, it's set at 9:45. All right. And so now we're looking at 3 minutes.
Very well, Judge. And if I may, just on a personal matter, Ms. Crittenden, are you related to Crystal Crittenden?
Yes, I am. I'm her mother.
All right.
Oh, wow.
She's my
Wow.
former supervisor. There we go. Small world.
Wow. It is a small world. Everybody knows Ms. Crittenden because she's been around working for the city law department for so many years. It's a pleasure to meet you this morning, ma'am. Of course,
I apologize for interrupting, Judge.
Oh, no. That's perfectly okay. That doesn't affect anything in this case. I have to decide the case on whatever is presented here. So it's good to have both of you here. Okay, so the way that this works, of course, is given that Ms. Crockett, you brought this claim, you have to tell me and establish by a preponderance of the evidence that you are entitled to some form of relief based upon a claim that is recognized at law. So tell me what this case is about, being reminded that you are under oath at this time, ma'am.
Absolutely. Thank you, Your Honor. I heard some work happening in my backyard around August 20th. I went outside. I saw a man with a yellow shirt, with green writing on it, a petite Black woman with blonde hair in the backyard, and they were cutting a tree on my side of the fence. I asked them to stop cutting it. They would not stop. I said that I was going to call the police. The man told me, call the police. They're not going to come anyway. So I called the police to ask them to stop cutting the trees on my side of the fence. They did not stop. The police came out, and that's when there was some conversation. But at that point, all of the limbs have been cut off, and they provide vegetation and shade on inside my yard. And I sent pictures showing my side of the fence. I showed pictures of all the branches that were cut. All of them, I would say 90% of those branches were on my side of the fence. This is the second time that I've had an issue with Mrs. Crittenden cutting limbs off. I've had to call the police in 2005 to ask her to stop. I called twice. Her daughter, Crystal, whom you mentioned, then came out and said,
well, I can't let you, I have to stop you there. I can't let you say what someone else said.
Right.
If Ms. Crittenden wishes to testify, she certainly can, but I can't let you tell me what she said to you.
That's fine. I understand. So that is the situation. The magistrate judge ruled that.
Well, I don't want to know what the magistrate ruled. I'm smarter than them. I'm just kidding, but procedurally that's not the way that we do it. So whatever they did is whatever they did. But I'm looking at this new and fresh.
And that's fine. And I've looked at MCL 600.2912, and it says in section 1C that if somebody cuts down or carries away any grass, hay, or any kind of grain from another's land without permission of the owner of the lands, then it's 3 times the amount of the actual damage. It's also MCL 750.552, trespass upon lands or premises. So the trespassing, those branches were cut in my yard. And so they had to go over my fence to cut those branches off of the trees. And I've lived in the neighborhood, just for some facts, since 1971. I've lived in this house since 1996. So I've been a neighbor abutting to Mrs. Crittenden for 26 years this year. And I was a young woman when the first issue started in 2005. So that's what happened. After I said, asked the people to stop cutting, then it was about 5 people there coming back in Mrs. Crittenden's yard. What's going on? It was, I guess, an effort to, and this is my testimony. under oath to intimidate me. There was a rough woman with shoulder length twist. And there were some other people in the backyard that came out about this situation. And I asked her why she didn't call me or anything before they started cutting down my branches, because we could have talked about it. And we could have come because we're neighbors. So yeah, that's my testimony.
Gotcha. And you said that happened on or about August 20th, 2021. Is that correct, ma'am?
It's around that time, because between noon and 12:15, I was taking care of my mother who's going through some physical issues. So it was a lot. Yeah.
All right. So this particular tree, before I go to the other side and hear from them, this is a tree and not a bush or something. What did you kind of describe that? I believe it's a mulberry tree. Okay. The roots are in my yard, and the branches are in my yard. And so, like I said, if Mrs. Crittenton had called me, we talked about it, we could have come to a resolution as opposed to just cutting down my tree, cutting the branches, and it was in my yard in which the branches were cut. All right, and the branches and the leaves or whatever from this tree, is it typical? Does a typical thing apply? That is, that they extend over into the adjoining neighbor's yard as well?
I don't pay attention. I pay attention to my side of the yard. I don't know.
So in other words, your answer is that you don't know.
Well, right. I show a picture and I see leaves, but I can't say specifically that those leaves on my picture are from the mulberry trees. They look like oak, the leaves. So
you're not, okay. So you're not sure. All right.
Not sure. They look different.
Gotcha. In relationship to the fencing that is there, is this a cyclone fence or some type of wood fence? What type of fencing is it?
It's a metal fence.
Okay.
It's a metal fence, and cyclone. I don't know what a cyclone fence is. All I know.
Yeah, like a chain link kind of fence with the poles.
Yes, it's a chain link fence.
All right, got you. In regard to this this fencing, to the best of your knowledge, how long has the fencing been there?
To the best of my knowledge, it was here when we bought the house in 1996 in April. So that's almost 26 years ago.
All right, it has not been updated since that time, to the best of your knowledge?
Not to my knowledge. No, I haven't.
All right.
Nor have.
And to the best of your knowledge, does this go along the lines of the typical situations in most residential communities, that the property line at that juncture is a shared property line between the neighbors?
I don't believe that it's shared, and the reason why I say that is because there's a dog run, and that's where the defendant's workers stepped into that dog run and started cutting trees on my property. So I would say that that area, and I think you can see it in the picture between, I don't know if you can see it.
Right. Do you have a way to, do you know how to share your picture on this device?
Okay, let me.
You could hold it up and let me see it at some point, but if you could share it, if you could put it in a share, that would be even better. Right.
Do you see? I'm sorry, I don't know how to put it in the share, and I don't want to waste your time.
You're not wasting. You're not wasting my time. Gotcha.
This right here, Your Honor. I'm sorry.
Hold on, I got too much.
Talking.
I got too much other noise going on somewhere.
Yeah.
Excuse me, Judge, it's the clerk. I was letting you know that Miss Angela, she sent those emails to you. They're in your email, the copies that she has.
Okay.
They're right in your email.
Sorry. Okay, you sent them to me, did you, Madam
Yes.
Clerk? Okay, 1 second.
Okay, sorry, Madam Clerk. Thank you.
And I did locate the actual file. They said it was upstairs.
Thank you so much. Appreciate you.
Well, just for the record, those are the great people that make me look good anywhere that I look good. That clerk and then that court reporter and that court officer. Well, let me see what I've got here. And Miss Crittenden, you don't have any objection to the court taking a look at the photograph that Miss Crockett is referring to. Is that correct?
Your question, please.
Yeah, regarding the photograph that that has been presented to the court regarding this particular property, you don't have an objection to the court taking a look at the photograph or photographs. Is that correct, ma'am?
No, as long as they are the same ones, Your Honor, that were presented to court the last time we went, I have no objection.
All right. So what I'm looking at is it looks like there are three. It looks like there are three photographs, and each of them seem to depict an area where there is a fence, and it looks like there are two fenced areas, and in that double fenced area there appears to be the roots or the branches of a tree. That seemed to make sense to you in terms of the photographs that you're familiar with, Ms. Crittenden?
The back that she's talking about, Your Honor, that's the dog run, and that's
okay.
Yeah.
I'll get back. I'll come to you and let you talk about that. But okay. a picture that depicts the, if you will, the dog run, and also a tree that has branches that appear to be cut branches, that would be a correct depiction of the area that we're talking about. Is that correct, ma'am?
I'm trying to think. It's the part that.
Okay, let me stop you. Because I don't want you to get into the details. I want you. What I'm simply getting at is to make sure that I'm referring to photographs that depict a dog run area that has that shows a tree that has branches and that has been cut. That's that's what I'm referring to. So that would seem to be consistent with what with photographs that you've seen regarding this, Ms. Crittenden. Is that correct?
Yes, Your Honor.
All right. So I'll admit those three as plaintiffs 1, A, B, and C. Just one moment here. Just one moment. All right. And so I also received from Ms. Crockett a FOIA reply that she apparently requested some information from the city of Detroit, and I think this was something related to 2015. Is that correct, Ms. Crockett?
Your Honor, the reason why I asked for the FOIA, so that what you have is showing the call, the police call, but and I know you just said you can't admit or can't listen to what was talked about in the other complaint, but so
well,
I was.
The fact that you contacted the police and came out, you've already made that clear on this court's record. All right. So anything else, Ms. Crockett, you want to tell me? I also noticed that you sent a document that has some estimates, and they relate to something. Tell me a little bit about that, if you will, ma'am.
So I had someone come out to give me an estimate of what it would cost, because again, that tree provided shade, and it blocks the neighbor's yard when everything is grown in. And since that's cut down, it hinders my ability to enjoy the backyard in privacy. And so what I did is I asked for an estimate. And so the estimate I sent the court is to remove that tree, take the stump out because it's in my yard, and replant other vegetation that will provide the same type of security and privacy that the other tree that Mrs. Crittenton cut down. So that's what the estimate is. It gives how much the cost of removing the stump and things of that sort. And I think that's the most expensive part, is to remove that stump. And just buying the plants and replanting them is not as
all right. And you have no idea how long that tree has been there.
I will tell you that tree has been there.
Sounds like the answer is no.
Well, specifically, I've been in this house since 1996. The tree has been there since I've been in this house.
Yeah, and that, I guess the easy answer to my question is you don't know how long that tree has been there.
I didn't plan it. No,
it could have been 50 years. It could have been 100 years. You just don't know. But you know it's been there all the time that you've been at that house, correct?
Yes. I'm sorry for not answering your question specifically.
That's all right. I usually get to the answers anyway, so it don't matter.
Not trying to cause any problems.
No, it's not a problem. This is the work that I love, and it's interesting as it gets sometimes. All right, thank you. All right, let's go to Ms. Crittenton. Let's find out what's going on here. Ms. Crittenton, let me ask you a question, then I'm going to let you talk freely to tell me what this case is about. And that, my question has to do with, typically there is this, where the boundary lines of the properties of parties exist, there is area that is treated as easement. And that's one of the challenges here. When I talk about shared boundary lines, I'm talking about easements. And those easements oftentimes give people opportunity to remove what they believe might be obstructions and so on and so forth. And of course, that's where conflicts tend to come into play. Tell me what, if anything, you know about what I'm talking about, and then tell me about your response to what Ms. Crockett has testified. Go right ahead, ma'am.
Yes, Your Honor. Actually, I'm 86 years old, and I've been living here.
Stay around me as long as you can, because now the 80s are relevant to me. When I was 40, who cares? Now
I thought 50 was old when I was little. But I've been here for 52 years. My husband and I purchased this house in 1970. Miss Crockett, she lives right behind me, and the fence that she's talking about was there when we moved here. It's part of the alley that the city has given to each property owner. The dog run is mine back there, and then I put another run that was to cut them off from coming into my yard, into the grassy part. Well, the trees that she's talking about actually were volunteer trees, like birds and wind bring the buds, and trees just pop up all over. Like, we live in Sherwood Forest, so we have a lot of trees here. We didn't plant those trees; they grew there. She's saying that it is the cyclone fence also, and what happened to the cyclone fence is that the weeds and the branches and all from the bottom, they eventually pushed through the cyclone, and they're on my property there. That property, I used to keep it cleared out back there in the back because it was a dog run. But in the year 2020, I came down with COVID. And so I did not have the opportunity at that time to do anything in my yard. In 2021, I had someone come over because by that time, there was infestations of rats, raccoons, and possums all back there. If I was still on my deck in the evening, the possums and the raccoons would come out. I had no peace there. Miss Crockett, however, it said this it was the trees were cut down. They weren't cut down, only the part that was hanging over into my part of the yard. I'm a realtor and I know what I can and can't do when it comes to removing of things that are not on my property. However, this is like the 5th time that Ms. Crockett has called the police on me. In 2005, she called the police and she said that my nephew, who was helping me clean out my garage in the yard, she called the police and told her that my nephew had broken into her house. The police came and they came with dogs and they said, no, the dogs took them straight to the cemetery from her house. They did not go through my yard. My nephew never left my site except when we went in to have lunch and go and clean up somewhat. At that time, the police officer told her, well, no, you don't have a case, and this man could not have done it.
Well, let me stop you. I can't take into consideration what a police officer may have spoken to you. So you can tell me what you did and what your response may have been, but what an officer said is not something I can take into consideration here. You may continue otherwise.
Thank you, Your Honor. Yes, well, what I would usually do is I would clean out the whole alley back there. Actually, it's an alley, and the dogs would go back there, and that was their exercise run. This went on and on. Every time I go out in order to clear out that back where foliage is running high and the bugs and all are back there, not allowing me, I cannot enjoy my yard. She says she can't enjoy hers because of these rodents. However, this last time when she called the police came. They told her that no, I had not.
You can't tell me what the police officer said. You can tell me what you did or what action you took. Go ahead, ma'am.
Okay. When there were I'm trying to get my thoughts together now.
That's all right. Take your time, ma'am.
Yes, well, the weeds and the foliage and the parts of the tree branches that had grown over into my yard were cut from my side of the yard. We never once entered her side of the yard. The whole tree was not cut down, only the branches that leaned over into my yard, they were trimmed. The tree that she's talking about is still standing there with the leaves going on the brooks, the trunk and everything on her side, but it's going over on her side. I did not ever have I touched her side of the property, been on her property to cut anything. And this is going on over and over and over, year after year. She's calling the police officers on me. She's taking me to court. This is the 2nd time. I can't continue to live like this with this woman. I'm sorry. When the officer came over the last time and they observed what was happening, I knew that I was with the right. I was told that it was my right, my side of the fence. And so this is one of those things that's going on and on and on. She is a chronic, I can't say she has like 20 cases now, lawsuits against different people. She sued the 2 people on each side of her last year or this year with me. We were all sued because of some type of foliage or tree trimming. This is ridiculous. In the last year, I've lost 14 relatives and friends to COVID. I too am myself a survivor of COVID. I just can't enjoy my property. I'm nervous when I go outside for fear that she is going to come over, strike up the conversation and call the police. I just need her to stop. Stop. Please stop this. I would not ever go onto her property and cut or destroy anything that belongs to her.
All right. Thank you. Thank you, Ms. Crittenden. Did you take any photographs or pictures before or after any activities that you may have engaged in regarding trimming the foliage, ma'am?
Yes, I did. They were on my camera, but I can't. My battery is down at this point, so you can see what I'm talking about. All right. I have no way of showing it to y'all, other than the fact that I can truthfully say that the person who was trimming my yard last year stayed on my property. Never once did he go on her property. It was not necessary because the branches grew through the cyclone fence. Anything that's on my side, we cut down. And I need to, because like I said, because I can't have a dog back there. I can't sit on my deck in the evening because all these rodents and all that come, they run back to that part of the yard. They're fed back there. I don't know how, but different. It's just terrible. And I've done nothing to offend Miss Crockett, not at all. But Mrs. Crockett needs help, and if she's willing, I will go with her so that she can get the help that she needs, because she is a chronic sewer. She sues everybody.
Well, I won't take that last one. I thought you were talking about helping her to cut some trees or something.
No tree. No tree.
All right. So let me ask you. So this area, Miss Crittenden, this area is that. I guess in the beginning I had the picture of these houses being side by side. You were back to back to each other, correct?
Yes. Yes.
The alley separates you, correct?
Yes.
Well, what used to be the alley, and once the alleys were closed, oftentimes there was fencing extended into the area that used to be alley. Is that about the size of what this is? Yes or no? I'll come to you in a moment, Miss Bassett. Miss Crockett.
We don't have an alley. When I moved here, we didn't have an alley.
Okay.
Okay, but if you look at the when we look at the description of land, you can see that that part is something that each person, each neighbor received when they eliminated alleys throughout the neighborhood or the city.
Yeah, got it.
But you know, one more thing, Your Honor. Mrs. Crockett has she has like 15 small things for
okay, you already told me about that.
Okay, well,
I'm just gonna deal with this one. If I had all 15 of them here today, I'd probably deal with all 15 of them. I'm crazy like that, but
okay.
Yeah, I understand, and there are some people that are more litigious than other people. I do have to consider what relevance that might have here, but here it seems like the two of you actually have a dispute that the court can address. In this case, the other stuff, maybe there are ways to address that, but I'm going to deal with this case today. All right, Miss Crockett, tell me what you have to say at this time, ma'am.
Thank you, Your Honor. First of all, my branches, as shown, the situation is shown in the pictures, show that the branches are on my side of the fence. And I do have a survey that I'd like to show, where it shows where my fence ends. So between what you have the pictures. So there's the dog run, but I'll show you. I don't know if you can see this, and I did not enter this into evidence, but up here is my fence, and going in this direction would be Mrs. Crententon's. This would be the dog run, and then her fence would be up here. This is a survey for my property. It is a cyclone fence. I disagree that is a Mrs. Crententon said it was she called this tree some type of I forget what she called it.
Rodents and etc.
Something that like the birds dry. This is not a hibiscus.
A nuisance. A nuisance is what she's saying.
Branches on her side. This is the same type of tree that and that's why I did the FOIA, because I wanted to have a record of how many times I called the police. And so based on FOIA and the department, the city of Detroit, they keep the records for 5 years. I requested 2003 to present. What I submitted was the past 5 years that I've called the EMS or 911 in regards to anything. So from 2021 to 15, I have not called the police on Mrs. Crententon. And that's why, because she said that, and that's why I submitted the FOIA, because that is documented. And also, if we had, I know it won't get to a subpoena for them to go back to 2003. So when Mrs. Crententon said I accused her nephew of breaking into my house, someone did break into my house in 2005, that her neighbors told me that it was her grandson.
Well, you know now. You already know.
Okay.
you know you can't you can't tell me about that. It's not relevant. It's the issue.
Yeah, and I understand, but I was accused of accusing her nephew, which I didn't do. And there's no record of my calling in the past 5 years on Mrs. Crentington. I guess a subpoena would, speak to 2013 to present. Mrs. Crentington also mentioned that, volunteer trees, that's what she said. So I disagree with that. I have a full-grown tree that it's a mulberry tree. The tree that was cut down was also a mulberry tree. The branches are in my yard. And Mrs. Crentington said they were only in her yard. That is not true. The branches in the picture shows where the roots are on that tree. And she says every time she goes out there, she can't enjoy her yard. And I strike up a conversation with her. I have too much going on in my life. This is my testimony. To pick on an 85-year-old. My mother's 83.
Hold on a second. I think she said, hold on. I think you said 86, did you?
Yes, I did.
We got to give her every single year.
Right.
Go ahead.
Because my mother's 83 and I'm taking care of her and helping her. Yeah. I have respect for older people, and it's painful to me that she would say that all I have to do is come out in the yard and strike up a conversation with her so I can take her to court. That's offensive, because I wouldn't want anybody to do that to my mother, which has happened. My mother lives across the street. So that's offensive to my character that I would do that to an older person, because I don't want that done to my mother. So when I did strike up a conversation with her, I heard a harmonica. She was playing Danny Boy, and I started clapping, and I didn't know who was playing it. It was Mrs. Crentington that was playing it. And I talked to her and told her how much I enjoyed that. Then after that, because it gave me peace, because I'm helping my mother. She lives by herself. So I don't have time. I have a full-time job. I have a family. I have a mother that's 3 years younger than her. I have other relatives that I'm taking care of. I don't have time to pick on Mrs. Crentington. I do not have 20 small claims court cases. And if I'm litigious, as she claims, it's because I believe in the judicial system, that the judges will take facts into consideration and they will follow law. Because I didn't talk to Mrs. Crentington. And when you first asked us if we spoke, she said yes. And I said no, because we haven't spoken. These other two people, and the issue is surrounding me. She brought up the other two. The other case, it was settled. I won the case on one side because the woman cut down my trees. I guess, I don't know, because I'm young or younger than them, or whatever. They feel like they can just do whatever they want to do on my property, and I'm just supposed to take it. So the one woman settled. The other woman is still pending the case. So yes, I have cases, and Mrs. Crentington behind me. I keep my yard clean. I don't have any loud music. I was raised, I don't have issues where I'm a nuisance to the neighborhood. And I know I can't bring in hearsay, but I do have hearsay to admit, but I can't bring it in. And so that's what I have to say. And I want Mrs. Crentington to be able to enjoy her yard, just like I want my mother, who lives across the street, to enjoy her yard as well. And I'll help her. I just don't even understand.
All right.
Chronic
Thank you.
cases.
Your Honor, may I say something, please?
Yes, Ms. Crentington.
Yes, when we were in court under magistrate, Mr. Boyer, she admitted that she had called the police on me 5 times. No. She admitted. Now she says she didn't. This is her second time having me in court. And I said, but she's continuously doing this, Your Honor. What do I have to gain going out there cutting down her trees when I have trees on my own property I have to take care of. And I have never tried to be anything but a good neighbor. I've been here, like I said, for 52 years, and several of those years I was the block captain. I know what my boundaries are. I don't want to tread on any of her. I don't want to disturb her. I want to have peace, just like I want to have peace myself. I was playing a harmonica. Yes, I played after my sister died from COVID and all the deaths. I took up playing the harmonica, and I can do that now. And in the daytime, I might sit out there and play for about 15 or 20 minutes, but not in the evening, because that's when we get the appearance of the raccoons, the possums, and the rats. I have exterminators who come out. I can get, she can see where the exterminators have been at. But if I have the pictures now in my camera showing what I cut down, the trees are still standing there, and they grow back every year. The weeds and the trees grow back every year, Your Honor. It's not like they've gone forever, but these are on my property. And I'm just trying to keep it safe for my dogs when they have to run back there and not be frightened by these critters.
All right. So, all right, ma'am. And I'm coming to Miss Crockett, as you will get the last word because you have the burden of proof here. So, ma'am, you learn how to blow the harmonica after age 80.
Yes. December of 2020, when my sister passed away from COVID, I just started playing the harmonica, and I played it at her funeral, and I've been playing it. Yes, self-taught. And I also play the saxophone. Yes, I do in my old age. And on my bucket list is for me to get on a horse. That's the one thing I haven't done.
That's my, I guess there's hope for me regarding the piano. All right, Ms. Crockett, we're back to you. You get the last word regarding this matter at this time, ma'am.
Thank you, Your Honor. In summary, I have shown pictures of where the roots are of the tree that was cut down. I have shown my fence and shown the branches on my side of the fence that were cut down by Mrs. Printington's workers. I have shown the fence line on the survey. This shows where my fence is. It doesn't show Mrs. Printington's dog run, but it shows where my fence is. And the trees were on my side of the fence. I refute, and I absolutely did not admit that I called the police 5 times on Mrs. Printington. That's why I submitted the FOIA under oath. I swore to tell the truth and the whole truth, which I did last time, and I'm doing now. Mrs. Printington called me a liar, and I said, I won't call you a liar, but I called the police 3 times, twice in 2005 and once in 2021. I don't have evidence of the Zoom hearing so that you could hear my testimony. I never said that I called the police 5 times. Mrs. Printington had her workers cut down branches on my side of the tree. As long as I've lived here, I've never seen a dog run in that dog run. And when I heard Mrs. Printington, because I garden, and in the summertime, I stay outside until the lights come on. You know, we had to come inside when the street lights come on. So that's how long
you're dating yourself now. Come on now.
I've been living here for 50. I've been living in Sherwood Forest on the same street for 51 years this year. So yeah, I am dating myself, but thank God, you know, thank God really in this environment. But I just want to say that under oath, I'm telling the truth, and I just want to be made whole. And I want the truth to prevail in this situation. We're looking at the facts. I did talk to Mrs. Printington. It was night because I stay outside in the yard gardening until the street lights come on, like I said before. And I've never seen any rats in my yard, thank God. So I just want this to be right. I just don't want to be taken advantage of. And that's what I believe based on the actions since 2005 when I was a younger woman, right? than I am now. But anyway, that's the facts. The trees were on my side of the yard. The root is in my side of the yard. Mrs. Crittenden had them cut down. She did not tell the truth about my calling the police on her 5 times. I called 3. I submitted the FOIA showing 1 call in the past 5 years. And that's it's not a volunteer tree. It's the same kind of tree that was she cut down in 2005 when I called the police the first time, and she wouldn't stop cutting the tree down until her cutting branches off until her daughter, Mrs. Attorney Crittenden, told her to stop. I'm sorry.
Can't let you get into that part of it, man.
Sorry.
Okay. All right. Anything else, ma'am? All right. You always get the last word because you have the burden of proof. All right. All right. Thank you very much. It has been a delight to listen to both of you, women who are alike in some significant ways and different in ways that are just as significant. You're alike in that you both care for and do all that you can to take care of your property, and that is a credit to your community, a credit to our city. I'd rather have individuals here disputing their differences about whether or not something constitutes taking care of property, as opposed to being here fighting about the fact that there is a total neglect of property by one person or the other. And just the opportunity to see two individuals who are delightful in the sense that they have participated and given themselves to carry out whatever their life's journeys are, the work and taking care of mother, learning how to play harmonica, gardening. All of these kind of issues show individuals who are teeming and alive with life. It's for whatever it's worth as it relates to both of you, disputes are a part of life. I mean, whether we have a court system or not, people have disputes. The best of people have disputes, and oftentimes inter-family disputes are in existence, and those sometimes are the worst among disputes. So it's not. It doesn't bring a sense of disdain to either one of you, the fact that you differ about some things or that you have a dispute. And additionally, it does not bring a sense of any kind of disdain that one person may feel the need to try and litigate something where another person may say that that's not important enough to litigate. People see things differently. And then the final thing I say before I get into the heart of this case is that people see and hear things differently and conclude things differently. Does not mean that people are lying. Sometimes what happens is that people's perspective and how they saw it, how they observed it, is different from how somebody else observed it, saw it, or what their perspective was. And oftentimes it is measured by what their preconceived notions were, their impressions were, what was affecting them that day. I've had cases where one person testifies that the car was going 40 miles an hour, the other said it was going 25. And nobody was really lying, but from the standpoint of their training, background, experience, one it appeared to be 40, another it appeared to be 25. I've had people say, well, the car was blue. The other one says, well, I'm absolutely certain that the car was green. Somebody said, well, they're lying because I know it was blue. You're lying because I know it was green. Well, I know neither one of them are lying. I know that they saw it differently because of the different position they were standing at, the stress that they were under, and sometimes just being slightly colorblind. In this case, the parties have a dispute that relates to the cutting down of a tree that is situated at or near or within property lines, and that trees are not obedient and respectful. They're wonderful, but they don't obey and respect that you should never grow into someone else's yard. You should only grow into the yard where you were planted. Not only does the trees do that in relationship to what is above ground, they are notorious for doing that in what is beneath the ground. the branches know no barriers. The roots know no barriers. They stretch out wherever they want to stretch out, and individuals have the right and the responsibility to engage in trying to clear areas that they believe would add value and add comfort to their properties. One of the important things to do is for neighbors to try and find ways to cooperate in getting that process taken care of. What was done here is that Ms. Crittenden herself and others assisted in removing branches that related to a tree, the roots of which are still there based upon the photographs that I observed. And the question that has been presented to this court is that the side of the where the trees grow that protrude into the yard of Miss Crockett, those were cut down, and those brought some shade to her, and that shade is eliminated. Ms. Crittenden contends that what she cut down was protruding into her property, and moreover, that her cutting and trimming was for the benefit of herself and everyone else involved, because it prevents rodents and what have you from harboring in like places. At the end of the day, really what you have here is you have a situation where the plaintiff cannot really meet the burden of proof to establish that she was damaged in this case. And her measure of damages, moreover, that relates to removing a stump and planting another tree, certainly is not a remedy that would be cognizable and reasonable under the circumstances presented here. This is a dispute that in all probability is adequately resolved by the parties seeking what is in the nature of an injunction in the appropriate court to, in fact, define what damage is being caused and what remedy there is to prevent such damage from being caused, and to enjoin parties from coming onto and or near the boundary lines of the other parties for purposes of even trimming the tree. But to the extent that there is damage that might occur as a result of that, then the parties might want to seek relief in that way. But here, this is a dispute that says, well, I cut it because it was doing this. The other one says, well, she cut it, it harmed me. One says it's on my property. The other says is not on my property. One says the tree doesn't even grow in that direction. The other one says, well, it certainly grows in that direction. What was not presented to me was a before. I certainly was able to see an after, but not a before. And seeing that before would be critical and crucial to this court being able to say, well, wow, that was indeed a mulberry bush that provided shade and whatever else was desired here, and that you went and you cut the shade out of the place. None of that is presented to me. The boundary line that was shown to me. The boundary line that was shown to me by Ms. Crockett is one of the most significant pieces of evidence or information. I did not admit it in evidence, but a significant piece of information that was presented here. But the reality of it is unequivocally that parties have the right to encroach upon the boundary lines of other parties for purposes of clearing what may be regarded as intrusions on their property. And that is what Ms. Crittenden has testified to. Now, do I know the ultimate facts of what occurred here? Well, without before and after photographs, without some testimony from persons who were there that may have removed branches, that may have cut things down, that can establish to me exactly what the condition was when they arrived, exactly what the condition was when they left from the property. Indeed, if I had a person that was in the nature of an expert that came out and said, listen, I came to this property and this is what the situation was. there was no need to trim anything, or there was a significant need to trim. Whatever the case is, none of that is anywhere on this record. This is a dispute between neighbors that cannot be resolved without more information brought into the setting, because it presents a situation where Miss Crockett has a burden that one might call it unfair, but it is a law. And Miss Crockett was very careful to say, I want this case decided according to the law. I want this case to be decided based upon the facts. I want fairness, and I didn't go and set a fire, and I didn't go fire a couple of shots and throw a couple of axes, because I want to come to the court system, because that's the way to do it. The worst thing, the thing that's really bad is not litigious. What's really bad is when the option to bringing litigation is to throw the axe, or fire the shot, or set something on fire, or tear something down. And that was not done here. This is bringing the matter to court and saying, court, I want you to look at this. I want you to think about it. I want you to tell me what you believe should be the outcome of this based upon your skill, training, knowledge, understanding, and application of the law. And what this case represents is a failure of the burden of proof, because the law imposes a burden of proof. It says that Miss Crockett has to establish by a preponderance of the evidence that the proposition she presents before the court is more likely true than something other than that. She has to preponderate. She has to present more evidence supporting the proposition than there is evidence either against the proposition, or that there is essentially a tie, essentially a situation that says that I'm agnostic to this. I don't know. I'm not sure. There may have been a little bit of this. There may have been a little bit of it. Maybe not. That's agnosticism. Just not sure. That just means that there's just not enough evidence. And the law requires that Miss Crockett preponderate, that she push it into an area that is so clear to this court, factually, that this court could not reach any other conclusion, but that she has, number one, been damaged, and then number two, that those damages are of such a nature that this court could grant an appropriate award in regard to such damages. My finding and determination here is that the plaintiff has not met the burden of proof. She's not preponderated. She's not presented sufficient evidence. And the reason for that, I think in this case, doesn't have anything to do with skillfulness or being smart. The reason for that is that the evidence is just not there. It's just not enough. And if you don't have it, you can't manufacture it. You can't make it up. You know, and in this case, that can happen. What would have helped, but nobody knows to do this. What would have helped was to keep a diary of how the tree grows, what it looks like when it's in full bloom, et cetera, and then to show me before and after. That could have helped. Also could have helped to have side profiles, lines drawn as to exactly what's mine, what's hers, and exactly what was did to cause harm. And of course, what it starts to sound like is that that's voluminous, and who would go through all of that? Who would go through all of those? They're already saying that I'm harassing them. Why would I go through all of that? Well, you probably shouldn't. But then if you don't, then when you come to court, you're not going to have enough evidence. And that's what this case is. I mean, I don't want to use the old adage that you're blessed if you don't, you're blessed if you do. But just take the blessed out and put the D word in. I don't really use that. That's kind of what it is. Blessed if you do, blessed if you don't. And that's what this case comes down to. So my determination is that there is no cause of action under these circumstances. Obviously, I suggest to the parties who have displayed in this hearing just an enormous amount of wisdom to use the wisdom, knowledge, and understanding that you both have to try and be the best neighbors that you can be, understanding that at the end of the day, you're not going to agree on some stuff. that, you know, and that's okay. You know, you're not, you know, you're not violently out there breaking windows, but you know, you're not gonna agree on everything, but to find a way to make this go forward in a meaningful kind of way in terms of your continuation as neighbors. I respect Miss Crockett's indication to the court that, you know what, I have a mother that's 83 years old, you know, and I'm taking care of her. I take care of my neighborhood, and I look out for my neighbors in some ways. I respect it, because I think that we really do have to, particularly in this time and season that we've been through in national politics and what have you, I think that it's important for us to love our neighbors and to look out for one another. And the expression of those kind of things is why I didn't interject too much during that time. The expression of doing those kinds of things is so critically important. And you almost have to leverage on that and say, well, how can we make this even better so that we don't deal with the stress of this on both sides, not just one person. The stress of one thing means something to one side, but it means something else to the other side. And we have to respect what it means on both sides. Sometimes I have the right to do something, but if my right to do it is going to cause distress to somebody that I care about, that I have to live around, then maybe even what I have the right to do, that I figure out another way of dealing with that. And that's a challenge. It's do unto others as you would have them to do unto you. It's that stuff that we all already know. We get it. But when it comes to working out practically, I mean, it's a challenge to do it, you know, but that's the life part of it. I only dealt with the case part of it. That's the life part of how you work all of this out. And in thinking about all of that, Miss Crittenden mentioned that she lost her sister in the middle of this COVID stuff, and she started to play harmonica. And this is, you know, you got to find a way in life. And I've already ruled in the case. 2 weeks ago, I buried somebody significant, you know, in my role as a pastor, minister. Last week, I buried somebody significant. On Tuesday, I got to bury somebody significant. I'm doing more funerals. I'm a judge every day, but I'm doing more funerals than it's unbelievable. And all of this is, most of it is secondary to this time that we are in. And all of us know that people are dying. But I think sometimes what we forget to do is to listen to people that are living in this environment where so many people are dying. You lose someone that maybe could have had a few more extended years if they had not entered into this COVID type situation. And your life becomes different, because now, you know that people are going to move on. But when you look at someone that you know that maybe they could have had a few more years, maybe many more years, but for this, and you got to deal with that, and you got to accept that, embrace it. And then when you count one, but then you look up and there are 2 or 3 or 4 or 5 people that you say that they didn't have to leave here. Why did this happen? Yeah, it's a certain amount of stress that goes with that. But I think that I think that it calls upon our humanity. And while, you know, I'm human just like you all. I made my ruling. You guys have jobs to do. You know how to do your job, and so on. And so I do my job to the best of my ability. At the end of the day, we got to find our humanity, and how is it that we address things with our humanity, because no system, legal or otherwise, will ever be able to capture all of the nuances of humanity. And that's only something that we can capture and find a way to plow forward with that. Well, it's been a delight sharing with you all. I made the decision that I have. My order will be consistent with that. I wish you well going forward. Nobody's moving, so somebody has to learn how to embrace neighboring in ways that are mutually beneficial, even if you don't agree with what turns one person on versus what turns on the other person. All right. So I wish you well. Good day to both of you. That's the
Thank you.
that's the end of this matter. All right. All the best to both.
Honor.
Thank
Good
you.
day to you. Thank you.
Thank you.
Mr. Lowe. Mr. Patterson is here. Man, Mr. Lowe, I thought you were in huge trouble. I just, the stakes were being prepared and I was looking for the fire, I'm being facetious, but we're on the record in 21-154-940. This is Affiliated Diagnostics of Oakland versus City of Detroit. There was a motion to dismiss this matter, and we put forth some effort. And Mr. Patterson was very clear regarding this city's position. And as you know, there's always been collegiality between you guys and the city. And I'm glad to see you here. Go ahead and in your appearance, Mr. Lowe. I do have Mr. Patterson's appearance already, sir.
Good morning, Your Honor. James Lowe on behalf of the plaintiff. And I apologize for not being here earlier. I looked at my calendar and this case is just not on it. I don't see a notice to appear. I did receive an email from Mr. Patterson. Thankfully, I saw the email and with the age of Zoom, I could actually appear right away.
Yes, sir.
I got to enjoy hearing the wisdom from the court as to the last case.
Wow, I didn't know. I wasn't thinking about you guys were here. I probably would have kept some of those words back, but it's still real though. Go ahead.
Yeah, no, it was well said. So I appreciated listening to that. But yes, I'm here and I apologize. Like I said, I don't see that we ever got notice. So, but I'm here.
All right. So I prepared an order that on the 29th of November, and then I have my clerk has the other notice to appear that was sent out. And anyway, I mean, you're here. I'm just wondering what happened here, because we have this notice going out to Mr. Law at the West 12 Mile Southfield location.
Yep.
And then Mr. Patterson. But gentlemen, I know you well enough that that's one of the good things about practicing in a particular area that brings you before a judge on a fairly consistent basis is they get to know some of your habits. And Mr. Patterson shows up for court. Mr. Lowe shows up for court. So,
yes.
so I asked Mr. Patterson to reach out to you because I know that Mr. Lowe shows up for court. I also know that this is a case that that some of the key people in the city consider to be a dog that barks loudly. There's something about this bus scenario that they believe that this is just sort of a pigeon drop type of situation. And I know that it puts some constraints that sometimes if there's a way to get rid of it, Mr. Patterson, they're saying go and get rid of that case because we don't like it anyway. But both sides are here. Where are we on this thing right now? What do you need from the court in terms of trying to go forward? It looks like it might be one of those that you're going to need a trial date on. But if there's something short of that, tell me about it.
Well, Your Honor, I haven't, because I didn't know about this ahead of time. I haven't done a deep dive into the file. But while the other case was being called, I did look at the notes a bit. I think we might be apart a bit in the numbers. My suggestion, and I did not get a chance to talk with Mr. Patterson before. I tried giving him a call, but I got a voicemail. Is that maybe this be sent to case evaluation to get just another pair of eyes on the case, because I know that with the motion for summary disposition that was denied, the city's going to take a strong position on this case. I think that between the two of us, we might need some help.
Judge, I believe you're muted. Judge, excuse me, Judge, I believe you're muted.
Judge, you're muted.
I was listening. I was listening and multitasking at the same time. So that's why I hit the mute button there. Yes.
Judge, imagine if you had a mute button for attorneys in court. You had enough, just mute.
Don't come up with any ideas like that, boy.
Judge, to respond to Mr. Lowe, I'm not opposed to the notion of some sort of mediation. I'm not necessarily in favor of case evaluation specifically. The reason, of course, being is that even if there is a case eval award that we would like to accept, it can be very, very difficult for us to push through in time to get into the accept reject. Of course, we can come back and do a motion to extend the accept. It creates, I think, sometimes more work than necessary. So I'm not opposed to mediation, but I would suggest an alternate route other than case evaluation, if the court would be so inclined.
Yeah, and I'm certainly fine with that. I know that with the city and a lot of these provider cases, we've got a stable of mediators that we all collectively use who know these types of cases very well. And I think, I don't know, Greg, if your client has any favorites, but I'm always happy with Doug Dempsey or Stu Weiner or Stu Frazier or really anybody the city would prefer.
Judge, if I may make a suggestion, this is not, I hate doing the posturing thing, but given the city's position on this case and where we're willing to go in settlement, because every case, no matter what I think of it, has some value, perhaps a more prudent option might be for Mr. Lowe and I to just take a month, see if we can't get this done before we expend $1,000 a piece on a mediator, where
that's the you kind of took the words out of my mouth on that part of it. If you're already talking about a case that some of the heads in the city are saying that case is kind of compromised a little bit already, and why are we paying money on it? And then we're going to go pay some money to have it evaluated or mediated. Then we're going to talk about value after that. Yeah, you might want. Well, let me ask you. How far are you apart? You just you don't have to tell me what your number is, but how far apart are you from each other in terms of trying to get this worked out?
So our bill totals $23,150, and my guess is based on I haven't heard Mr. Patterson's number, but I guess my guess is we're going to be very far apart.
Yeah, but when you're typically significantly apart from the top number in your in the medical billing. I mean, in other words, I think that in the vast majority of cases, when that bill hits 15,000 plus, it presses a harder settlement, given where the city is in terms of they're trying to cap things for a year and trying to convince city council to go a certain way. So that's a part of the challenge. And obviously the other side of that is when we talk about trial. So the reason I kind of bring that up is because I'm a mediator too. It's just, and at the end of trial, I'm an arbitrator. And so sometimes, where the parties can talk and where the court can chime in a little bit, maybe I can assist with saying, well, maybe you need to think about this, and maybe you don't need to think about that, and maybe there's a way to kind of to make that happen. It seems to me that, given some of the strange factual nuances in this case, that Mr. Patterson getting authority to jump that high is going to be really, a real, it's going to be Herculean, shall we say? But again, I know that Mr. Lowell, that your clients develop a certain expectation that arises from services provided, and so that's a part of the challenge as well. But they realize that they have to deal with they have to take their patient as they find them.
Sure.
And, just like we take the clients and whatever, they take their patients as they find them. So that becomes a challenge. So if you want to take a moment in a breakout to see how far you really are apart and talking with each other now, and then see if the court can make any suggestions or anything, if we could do it that way, or I could just give you the 30 days and let her rip. Mr. Patterson.
I think it might be more helpful to just give us the 30 days because, Mr. Patterson can talk with my office back and forth, and then we can communicate with our respective clients. I don't think we can do that on the fly this morning. I defer to Mr. Patterson, but that's at least my 2 cents.
Your Honor, I would be inclined to agree, and I do have another matter coming up. No disrespect to the court, but I didn't anticipate being here till 11:30.
Yeah, and that's absolutely. So we'll do it. We'll do it that way, and there will be many other opportunities for the court to display its well-gained skill over the almost 40 years of doing this.
Yes.
All right. So Madam Clerk, if you could give me a date that's like 30 days out or so, is that going to put us at? Go ahead, Madam Clerk. I'm sorry.
You have like towards you can do the 16th or you can do the 29th.
Are you in the month of March? No, bring me earlier. Bring me earlier in March, if you will. So that's somewhere between the 1st and the 7th or so.
The 1st and the 2nd.
Okay. Let's do a 3-2.
Your Honor, I do have a facilitation on the 2nd at 9 a.m. I'm assuming that'll be via phone, but it may create a conflict. I'm available on either the 1st or the 3rd if either of those days would work for the court.
Gotcha. Can we do it the 3rd, Madam?
The 3rd, you have too many cases. Can you do the 16th, Judge? Is that good?
That's way out. All right. I don't want to give these guys too much time, but don't tell them I said that. But all right. All right. What you saying, the 16th of March?
Yes.
All right. 3/16/20. All right. So 3/16/22, and I'll set that at 9:45.
9:45. Thank you very much, Judge. I do appreciate it.
Thank you, gentlemen.
Thank you as well.
All right. Good day to you.
Take care, Judge.
Thank you.